Hello everyone, this is your host Urvashi Chauhan. Welcome back to another episode of Courts Today by Live Law, your one-step destination to all legal developments in the country. Let us start. Starting with an update on the massive fire that broke out 2 days ago at the TRP game zone in Rajkot, Gujarat, which claimed 28 lives, including 4 children under the age of 12 years. Today, the Gujarat High Court sharply criticized the Rajkot municipal body and the state government after it was revealed that 2 gaming zones in Rajkot had been operating for over 2 years without the necessary permits. The hearing was conducted before a division bench comprising Justices Biren Vaishnav and Devan M. Desai. The bench expressed its frustration, saying that it was only the death of innocent children and young ones that had opened the eyes of authorities at a stage when the families of Rajkot have lost their loved ones. Advocate Manisha Lavkumar Shah, representing the state government, stated that an FIR had been filed and the owner of the gaming zone had been arrested along with the manager. She said that steps were being taken to ensure the arrest of the remaining owners of the gaming zone and a lookout notice had been issued. The court was informed that in the case of the gaming zone where the unfortunate incident occurred, there was neither an occupancy certificate nor an application for such a certificate. Similarly, no fire occupancy certificate was applied for. The court pointedly questioned the inaction of the authorities in even inspecting the site in light of the regulations to consider whether a so-called game zone existed and flourished at the cost of the lives of the children lost. The court said that the municipal officers who were in position from the inception of the gaming zone until the date of the incident should be held accountable for the tragedy that had occurred. The court directed the Commissioner of the Rajkot Municipal Corporation as well as the officers who held the position from July 2021 until the date of the incident to file affidavits before the court explaining what actions were taken regarding the following of guidelines in this regard. The court further directed the commissioners of Ahmedabad, Vadodara and Surat municipal corporations to file affidavits explaining the actions they have taken to ensure compliance with the court's order in the Fire Safety PIL. Additionally, the court directed the commissioners to provide a list of gaming zones and recreational centers in their jurisdictions indicating whether these establishments are in compliance or non-compliance with regulations. Instructions have been issued across the state to halt all gaming zones pending further investigation and inquiries. The matter is now listed for further hearing on 6th June. Stay tuned. In the latest development, Delhi Chief Minister Arvind Kejriwal has moved the Supreme Court seeking extension of the interim bail granted to him in the Delhi liquor policy case on 10th May. As you are aware, the bench of Justices Sanjeev Khanna and Dipankar Datta had granted him the benefit of interim bail till 1st June to campaign for the Lok Sabha elections subject to certain conditions. The court had observed that it was dealing with the case of an elected chief minister who was not a threat to the society. It was further noted that ED investigation remained pending for about 1.5 years before Kejriwal's ultimate arrest shortly after elections were notified. Therefore, according to the court, a liberal view was justified, also as general elections were ongoing, which are a once-in-5 years affair. Kejriwal, who was released from judicial custody as an interim measure, has now said that he has to undergo diagnostic tests, including PET-CT scan. He thus seeks an extension of the relief for a period of 7 days. Kejriwal was arrested by ED from his residence in March this year in the alleged Delhi liquor policy scam. The Supreme Court today refused to entertain a plea filed by Bharatiya Janata Party against the order of the Calcutta High Court that restrained it from publishing certain advertisements in respect of All India Trinamool Congress during the Lok Sabha elections. The ads were allegedly derogatory and violated the Model Code of Conduct. The matter was today heard by the bench of Justices J.K. Maheshwari and K.V. Vishwanathan. It refused to interfere with the High Court's orders after perusing the record. It found the advertisements prima facie derogatory. When senior advocate P.S. Patwalia, appearing for BJP, asserted that the advertisements were based on facts, the court replied that this was not in the interests of the voter. Following the disinclination expressed by the bench, Patwalia chose to withdraw the petition seeking liberty to file reply before the High Court single bench, which passed the interim order. Accordingly, the petition was dismissed as withdrawn. After the matter was over, Justice Vishwanathan commented and said that your rival is not your enemy. Delhi and various other parts of the country are experiencing a scorching heat wave with temperatures soaring to record highs. The relentless sun and rising mercury levels are making daily life challenging as residents struggle to cope with the extreme heat. A writ petition has been filed in the Supreme Court seeking directions to amend the rules and the Advocates Act 1961 to exempt the lawyers from wearing the traditional black coats and gowns in the scorching heat of the summer months. The petition further seeks to direct the state bar councils to determine months of prevailing summer for each state in order to exempt the wearing of black coats and gowns for those months. It is additionally prayed for the setting up of a committee of medical experts to study how wearing warm clothes in summer affects the health, work capacity and quality of work for advocates and suggest recommendations accordingly. Additionally, it is argued that lawyers should also have the freedom to dress comfortably, which is a part of the right to freedom of speech and expression. Let me tell you, the petitioner here had earlier approached the Supreme Court in 2022 seeking the same relief, which was withdrawn to file a representation before the Bar Council of India. The Supreme Court bench of Justices Suryakant and K.V. Vishwanathan has refused to accept the argument that commitments in a political party's manifesto leading to financial help for the public amount to corrupt practices by a candidate of that party. Corrupt practices are defined under Section 123 of the Representation of People's Act. These include acts like bribery, undue influence, etc., and are considered illegal and can lead to disqualification of a candidate. The main contention in this case was that guarantees in the manifesto amounted to corrupt practices, and for that reason it was prayed that the election of a winning candidate from the Indian National Congress be set aside. The appeal was filed against the Karnataka High Court's order, which dismissed an election petition filed by a voter against this Congress candidate. The court, while dismissing the appeal, said that the argument that a political party's manifesto promises, which leads to financial help for the public, amounts to corrupt practices by the candidate was too far-fetched and could not be accepted. The court has left the question of law open for consideration in an appropriate case. Also, let me remind you here that a PIL seeking to stop political parties from promising freebies in election manifestos is pending before the Supreme Court. Cricketer Yuvraj Singh has invoked arbitration against a developer for allegedly violating his privacy rights while promoting a real estate project and for failing to deliver an apartment in the project on time in the national capital. Singh has sent 2 notices invoking arbitration to the developer Brilliant Elite Private Limited. He has said that the developer misused his brand value and contravened the terms of the Memorandum of Understanding. As per the MOU, Singh was to promote and endorse the project in question. The MOU expired on November 23rd last year. Singh is aggrieved by the alleged continued commercial use of the services provided by him, including the use of his photographs on billboards, project site, social media posts, articles, etc. Despite expiry of the MOU. This, as per the cricketer, is a complete violation of his copyright and personality rights. The second notice concerning possession of a flat in the project states that the developer has failed to adhere to the timeline and schedule of delivery and thus acted in contravention of the agreement to sale. Singh has further alleged that the developer compromised on the quality of the material used in the apartment and downgraded the quality of fittings, furnishings, lighting and finishing. And lastly, the Kerala High Court has held that violation of bail condition by the accused was akin to misusing the liberty bestowed upon him by the court and was a ground for cancellation of the bail. In this case, the petitioner was accused of offences under the NDPS Act and the Juvenile Justice Act. He was granted bail with certain conditions, and one condition was that he would not be involved in any other crime during the bail period. However, he allegedly committed another NDPS Act offence, leading the prosecution to seek cancellation of his bail. The special court revoked his bail and the petitioner appealed to the High Court to quash this cancellation order. In the facts of the case, the court found that the petitioner, who was bound to follow the bail conditions of the special court, violated it. Referring to apex court decisions, Justice A. Bahaduruddin held that the court granting bail after imposing conditions has the power to cancel the bail order if any of those bail conditions are violated. If you wish to know more details about the cases I mentioned here, you can visit our website at www.livelaw.in. Stay ahead with quick legal updates only on Live Law. Do not forget to like, share and subscribe and support us. You can also support us by donating through the thanks button at the bottom of our videos or consider becoming a member at just 89 rupees per month.